Good day, everybody. I hope everyone's day was going well. Today's webinar, short webinar, is to talk to you a little bit about the dental office lease agreement as it relates to your practice, but more particularly how to set up properly the use provision and negotiate exclusivity agreements to add a layer of protection as well as value and a growth strategy for your practice. And so my name is Jared. I've been with Cirrus for a couple years now, one of the consultants here. And before we delve into anything specific about the lease agreement, I want to just give you a little bit of background about our firm. So we've been in business for about 20 years. We work exclusively with medical professionals, the vast majority of which are dentists. And so dentistry is definitely unique in the sense that it's very expensive to either buy or build out a practice. So it becomes much more important for you to be protected through the terms and provisions of your lease agreement than the average type of commercial tenant. And so over the course of a given year, we will review and analyze approximately 1,000 office leases, of which we negotiate about 500 to 700 of those. So we've negotiated over 10,000 leases over the course of our existence. Definitely has given us a good history of data to refer back to regarding future negotiations. So we'll conduct a lot of continuing education courses like this, both online and physical seminars as well. And so we are fully CE accredited. So you will be getting your one CE credit emailed to you within the next couple of business days. Just to give you a sense, I guess, of some customers that we've worked with both in Canada and the United States. And so we've really done business in the U.S. In every corner of the country, from Maine, Florida, Washington, California. Last year, I think we negotiated about 12.5 or so deals in Hawaii. And so the reason I mention this is through getting involved in lease negotiations all across the country, we've really run into every situation that you can imagine, every type of landlord, from the largest institutional landlords in Chicago, New York, San Francisco, to say a lot of small to medium-sized commercial landlords across the country, and then a lot of smaller mom-and-pop landlords, even past dental practitioners. And for those of you joining us from Canada as well, just to give you a scope or the sense of the work that we've done really all across the country. The other thing to mention is there really is no one-size-fits-all lease agreement or approach to a negotiation. And so over the course of our existence, having worked with every type of landlord, geographically spread out, we've really come to a strong understanding of how to approach each given situation for that client's particular needs and for that particular landlord that we might be dealing with as well. And so really the purpose of today's webinar is, first of all, to give you a little bit of a broad sense about the lease agreement as it relates to your practice, how to negotiate some sort of exclusivity protection. Another word for this that some of you might have heard is a non-compete provision, ensuring as you relate it more to transferability and growing your practice, allowing you to bring on associates if that's something that you've thought about, depending on what your growth or transition plan might look like, maximizing that growth plan through a properly structured use clause, and then as well discuss a little bit how these clauses can negatively affect your ability or the value of the sale of your practice. And then ultimately going through some strategies of an action plan for those of you who might be approaching in negotiations. I will mention this a couple times, but at the conclusion of the webinar, I will leave my information up All of you are eligible for taking advantage of a complimentary lease consultation for joining us this evening or afternoon, depending on where you are, and so keep that in mind. So as far as what your lease should do for you, kind of speaking more broadly, there's a couple key provisions and purposes that you need to look for in structuring a lease agreement. So the first is obviously providing fair and affordable financial terms. And so we license a software, it's called CoStar. It costs us quite a significant amount in fees every year, but essentially what it does is it gives us the ability to pull information on vacancy rates, rental rates anywhere in the country. And so essentially when we pull these reports, there's typically 3 separate reports that we look at. The first being a building report, if it's available, showing when was your building built out, what type of building is it, class A, B, or C, retail, how much availability there might be in the building, and what the going rental rates are. And we'll also pull reports on buildings in the surrounding area to get a sense of what you're paying in rent relative to the market, and take a look generally at occupancy and rental rates. And so there's a tremendous amount of value in having these resources. Typically, when we're thinking about fair and affordable financial terms, we think about it both internally and externally. So internally, you have to think about it as what am I paying rent relative to my production. Typically, you want to be in the 5 to 10% range, no higher than 10%. Ultimately, there are calls that I will get on, every week or so where someone says to me, my rent is too high, and we take a look at what going rents are in the area, and ultimately they are fair market, so it might be a production problem. So either way, we have the capacity to pull this information anywhere in the country. And so for those of you who are a little bit more interested in diving into the details of their rental rates, definitely can look to set some time up to discuss that in further detail. The other thing is long-term stability and security. And so of the 500 to 700 lease agreements that we'll negotiate over the course of a given year, I would say the vast majority of those, we are signing longer-term lease commitments. So typically a 10-year lease with multiple, usually 2 5-year options to renew. There's several reasons why it makes sense for you to do this. First of all, whether you buy or build a practice, there's a significant investment that you're making at moving into practice ownership. So if you're looking at building out, you're looking at maybe $80 to $125 a square foot just in building out the tenant improvements. You want to protect that investment through a long-term lease agreement. The other thing is when you offer a longer-term lease agreement, it does typically increase your leverage and ability to negotiate all of the other terms and provisions in your lease, including rental rates, use provisions, among others. And then the last thing is actually transferring the practice, which I'll talk about in a little bit more detail in a minute. But I speak to a lot of doctors in their 60s, and they say, well, why would I sign a long-term lease agreement? I'm thinking of retiring in 5 years. Well, most banks will require a minimum of about 7 to 10 years of term remaining on the lease agreement in order to finance an acquisition. And so that's why we typically advise, among other reasons, to structure long-term agreements. When you're thinking about minimizing risk and exposure, it's particularly related to separating your personal assets from the business. And so for those of you who have your lease agreement in front of you, and I urge all of you to pull out a copy either later this evening or this week to cross-reference what we're discussing here today. But first of all, are you incorporated? If you're incorporated, have you signed the lease agreement under your corporate entity? And if you've signed the lease under your corporate entity, have you provided a personal guarantee or indemnifier behind that? The vast majority of doctors we speak with, unfortunately to us, have signed their lease agreement in some capacity in their personal name. So what that essentially means is if there's ever any type of dispute, that the landlord could come after not just the business assets, but all of your personal assets as well. So your car, your home, any joint assets you might have with a spouse, not ideal from a liability sense. When we're speaking with doctors in their 30s building out their first practice, the landlord has a much stronger argument for requesting that personal guarantee. But when you think about in a more established clinic where you have default rates for dentists at about 2.5%, if you're in a retail strip plaza and you compare that to the default rates of a restaurant closer to 90%, doesn't make as much sense. And so always want to make sure that you're trying to minimize your risk and exposure through the guarantee. Enhancing your ability to sell. So we're going to talk a little bit later about what goes into that. But when you think about things like use provisions and exclusivity clauses, all other things equal, a strong lease agreement will have a much better effect on the value, or more positive, I should say, effect on the value of your practice than another practice, all things equal. And so if you're in a retail plaza and you're able to negotiate things like non-compete rights with a strong lease agreement, it's definitely going to enhance your ability to sell and maximizing your flexibility. And so for any of you who are ever thinking about selling your practice, which I hope all of you have your hands up, even though I can't see any of you today, there's something within the lease agreement called the assignment and subletting provision. And so essentially, when you look to sell your practice, the sale is completely contingent or dependent on the landlord approving the transfer between buyer and seller. And landlords are synonymous for making this process very drawn out, very difficult. And so regardless of whether you're opening up your first practice from scratch, or you're 65 years old and you're thinking about retiring in the next 6 months, it's always to your benefit to have a strongly worded assignment provision to maximize your flexibility to sell. So remember, always going to be to your benefit to have that properly structured. So again, when we're talking about enhancing the sale, there's really 3 sellable components. There's your goodwill, so your patient charts, your equipment, so whatever physical equipment you have, and the third thing is the lease agreement. Not only will the lease agreement and the assignment provision facilitate your ability to sell, but it will actually increase and maximize the value if negotiated properly. So you always want to make sure you're looking at your lease agreement not only to facilitate transfer, but to maximize value. And so just a little fact here, did you know that exclusivity language in your dental office lease can permit the landlord to move competing dentists into the building or center? And so we're going to talk about this more broadly as it relates to the use provision. But generally speaking, you want to have exclusivity language or non-compete language. Otherwise, the landlord has the ability to move in competing dentists. And that can be, if you're a general dentist, another general dentist, if you're a specialist. I know from a lot of people that I'm speaking to these days, more dentists are keeping more and more services in-house. And so there's a blurred line or gray area that's continuing to grow every day between what was traditionally purely general dentistry or oral hygiene and other types of specialties. And so the way that you protect your business from having competitors moving in is to push to negotiate some sort of exclusivity or non-compete clause. And when this is properly written, it will protect the practice from prohibiting other dentists or specialists from moving into the into the premises. And keep in mind, I've spoken with doctors who have exclusivity in a retail center or in a medical office building across all specialties, and the landlord approaches them and they might have a specialist, say an orthodontist that is looking at space, thinking about moving in, and for that individual, they don't really practice a lot of competitive services. So I've definitely heard instances of them giving your approval, but by doing this, you are really putting the cards in your hand or the ball in your court as far as having some sort of say in what the tenant mix might look like. Now, for those of you who are in a building or in a retail center or plaza that has multiple doctors, you can look to negotiate some sort of limited exclusivity. So if you're in a building and there's 2 general dentists, it's going to be very difficult depending on the relationship or when that lease agreement might be expiring to actually relocate or kick out another doctor. But you can limit how many total doctors of that or specialists are in that particular building. And so when we think about kind of the power of a non-compete clause, it's important to be specific. So generally speaking, when we look at all the terms and provisions, we want to get as granular as possible. And so, for example, a lot of people, and for some of you who might be in New York or California, they often operate off of these 2 or 3 page standard form state commercial lease agreements. And I'll speak to someone and they'll say, well, my lease is only 4 or 5 pages. There's nothing too specific, so the landlord can't really do anything. It's actually the opposite. And so, the less detailed any particular clause is laid out, the more room for interpretation or ambiguity. And if a landlord wants to act on that, and we've seen some very difficult cases, ultimately someone might have emotion get the best of them and think that it's going to be in their best interest to move towards some sort of litigation. Very expensive. Landlords almost always have deeper pockets, and so you're much better suited to actually get more granular and specific, not just about the use provision, but all provisions. So generally speaking, most use provisions will state something along the lines of that the premises can be used either as a business office, general dentistry. When we get involved, we look to get much more specific. So not only say general dentistry, but include some sort of proprietary definition that we have to include, all specialists, so endo, ortho, perio, any other services that you might be offering. Reason being is, in November last year, as an example, I was speaking to a doctor out in Northern California, a little bit south of the Bay Area, and he had been in his space for about 15 years, had recently signed a lease agreement. The building was sold. His lease agreement stated that the use provision really only covered general dentistry. And he practiced a lot of orthodontics, so he was practicing, offering a lot of Invisalign, other types of procedures. There was an orthodontist that moved into the building that was able to negotiate an exclusivity agreement. They outlined the particular procedures. Our client was then hit with a cease and desist letter, essentially stating that he was no longer able to offer any services in relation to that specialty. Now, for this individual, the work that he was offering under that umbrella represented about 35% of his total production. You can imagine kind of the predicament that he was put in, and so he considered going down a litigation route, but decided that the smarter decision was just going to be to relocate the practice. For someone that was in a space for 15 years, not an ideal position to be in. On a lesser scale, just this morning I was talking to a dentist that did work with some pediatrics, and a pedo had moved in, and so she's seeing patient loss there. And so always best to really lay out a clear definition. So the use provision, again, in the office lease outlines the services that you are permitted to perform in your space. To take it a step further, and when you think about marketing your practice for sale, we typically recommend outlining even services that you might not be offering now, that you might think to offer in the future, or that you think might be attractive to a prospective buyer. And so when you're outlining the use provision, it's going to be to your benefit to really extend the definition to give you that flexibility. So again, the details of the use can be extremely detrimental to the practice growth when you think about expanding service offerings. And so no sense in really limiting yourself about where you think that you might want to maneuver or grow the practice 5, 10 years down the road. So again, when thinking about the use provision within the lease agreement, it outlines the activities or services that you are permitted to perform. It should not limit your ability to adapt or grow your business. And the details often get overlooked, which can be extremely detrimental to eventual practice growth. Also, when you think about exclusivity, be very careful, even if you're able to negotiate one, about what the landlord's development plans might look like, exactly what it covers. There's a recent case I dealt with where there was a retail strip plaza. The doctor had exclusivity. There was a very small 2-tenant building that was put in the middle of the parking lot, essentially. And a dentist moved into one of the 2 spots where the exclusivity only covered that initial building. So keep that in mind as well. So if you think about optimizing or growing your practice with strong use language, again, when we're thinking about marketing the practice for sale, it will increase who you can eventually market the practice to for sale. I'm of the opinion that, as has been a trend, say the last decade or so, that doctors will continue to put more emphasis on continuing education, continue to want to have a larger umbrella of service offerings that they can provide for their patients, and thus makes it beneficial to have the use provision structured in a kind of broad term for you moving forward, and then particularly as you think about actually assigning or selling the practice. So when you think about the practice sale, we'll talk about practice sale now for a couple minutes, is appealing to future buyers and adding that growth. So I do want to, because it's so critical and most people really just aren't aware, again, when you look to sell your business, the sale is completely contingent and dependent on the landlord approving the transfer between you, the buyer, and you, the seller. And so you might have spent 25 years growing your business. It might have been appraised at $1 million, but you can't see $1 of that unless the landlord actually approves the transfer from you to the buyer. And so if everyone wants to just take about a minute or so right here to review the assignment provision, and then we're going to walk through the example in detail. And so if we go through the example now, so it says, the first line says, if the tenant should wish to assign or sublet the leased premises, it shall first have received the consent of the landlord. The issue here is, from our experience, consent of the landlord is very arbitrary. So when we get involved, just like the use provision, we look to get much more granular and specific about what the process should look like. So if someone is licensed in your particular state or province, if they have good credit, no history of bankruptcy, and if the banks have done their due diligence, that's really all that should be required for the landlord to approve the transfer between buyer and seller. Okay? It goes on to say that after they receive the consent, the landlord shall have the option to either terminate the lease or revise the minimum rent to the greater of the then current market rent or 15% of that rate. A lot of the times, and you're reading that correctly, landlords will include termination rights, where simply by requesting to transfer the lease agreement, the landlord actually can terminate your lease. Reason being is they want to maximize the flexibility that they have in essentially the tenant mix. And also, something we're seeing that's becoming much more common and a serious concern is essentially landlords are realizing that when a dentist goes to sell their business, there's a large exchange between buyer and seller. And so they will leverage their ability to approve or deny the transfer of the lease agreement, oftentimes to ask for some sort of remuneration in a percentage of the sale proceeds. And so just this week, I'm dealing with a doctor in the north end of Chicago who's selling his business for $1.3 million, and the landlord has asked for 30% of the sale proceeds. So serious concerns in how this gets structured. And then lastly, it says that the tenant shall not be released from its obligations under the lease agreement. So essentially what this states is, even if you sell your business, you're still liable for the terms and provisions of the lease, meaning if whoever buys your business runs into any issues with the landlord, that you would still be on the hook. So serious concern. If any of you would like us to take a look at your assignment provision in more detail, again, you are eligible for the complimentary review and assessment. Keep in mind, this short webinar this evening kind of focused on the use provision and assignment, taught you a little bit more broadly about the practice, but really there are a bucket list of items that we look at in a given analysis and negotiation. Things like, relocation and demolition clauses. Can the landlord move you into another space? Serious concern given the build-out. Surrender provisions. So what are your obligations if you're handing over the keys? So in the interest of time, we really focused on the use and some other provisions, but there are a laundry list of items that we look at and that we would go through as part of our analysis. And so very generally speaking, some high-level concepts about things to be worrying about. One is the economics, so strong rental rates, really making sure that you're negotiating strong base rents, managing your escalations, managing what's called your triple net provisions otherwise, talking about the protection, so giving yourself long-term flexibility through negotiating those option periods. The other thing to keep in mind, making sure that those options are actually transferable to a prospective buyer. Flexibility, so the exclusivity agreement, giving yourself flexibility over tenant ownership. The assignment provision, making sure that you can sell your practice, as well as the death and disability provision, which the death and disability provision, for those of you who don't know, essentially protects you, God forbid something happens where you can no longer practice. In those instances, ideally, you would look to immediately sell the practice. If you could not immediately sell the practice, what the death and disability provision does is it essentially gives you the ability to terminate your lease. So it acts like a kind of insurance policy that you're not paying any premiums on, and managing risk through things like the relocation and demolition provision. And so the easiest thing to take away tonight is timing is everything. And I'm going to say that once more, very easy thing to take away. Timing is everything. And so most people leave the lease negotiations till too late in the process. So ideally speaking, we want to get involved, 24 or even 36 months prior to the expiration. The closer that you get to the expiration of your lease agreement, the less leverage that you have. Again, the closer that you get to the expiration of your lease, the less leverage that you have. Landlords, especially smart landlords, are very good at delaying the process to get you closer and closer to that expiration. Keep in mind that if you have options to renew, they have to actually be exercised within a certain window. So you might have a lease agreement expiring December 31st, 2017, but you actually have to exercise your option 6 or 9 months prior. And so for those reasons, among others, always want to make sure that you're starting the process as early as possible. Now, for those of you who have your lease in front of you and your lease is expiring in 3 months, don't lose all your sleep tonight. We get involved in a ton of situations like that, but ideally speaking, we do want to start the process as early as possible. So lastly, talking a little bit about a treatment plan quickly. And so if you start up in the pink tab there, tab number 1, make sure you're gathering all documentation. And so oftentimes I'll speak to someone and they'll be interested in having a lease consultation, and they'll ask their business manager or their office manager and look in their house. They can't even find the lease. Make sure you're keeping it. Make sure anytime a building gets sold or there's amendments, you're gathering all the documentation. So the way that our process works is once we get the documentation and review it, which I will talk a little bit more about that process, we got to identify those practice and career goals. So we would, moving on to section 3, review the office lease for risks. Take a look at all the legal terms and provisions, go over personal guarantees, assignments, relocation, use provision. Step 4 is to prepare our market research. So that's where our market research team will actually pull reports on vacancy rates, rental rates, really anywhere in the country. And again, this is something that you do have available to you for your reference. And then step 5 is the outcome and strategy. And so the complementary lease analysis that I've mentioned here a few times really goes through those first 5 steps. After we review everything, we will get on a phone call, typically lasts about 45 minutes to an hour. Before we talk about the lease or anything, we will have a detailed conversation about yourself, the history of the practice, what are your long-term goals and objectives. Reason being is the goals of the negotiation for a 30-year-old doctor building out a practice from scratch are going to be different than that for a 64-year-old doctor looking at transitioning. And so if you think about what we've done here, what have we not done yet? What we have not done yet is actually pick up the phone and call the landlord. And so what do most people do when they think about negotiating? What's the first thing that they do? They pick up the phone and they call the landlord. Much smarter strategy to lay out a process in place up front and goals and objectives before reaching out. Then we would negotiate all of the economics. So step 6, base rents, increases. If you're building out a practice from scratch, there's some additional elements that I'd be happy to discuss at another date. negotiate all the lease terms, make sure we're limiting liability, maximizing flexibility, putting yourself in a position where you're maximizing your flexibility, growth, and strategies moving forward. And then the last step is really the final review and execution. And so you wouldn't believe how many times we spend 30, 40 hours trying to negotiate with someone, and then all of a sudden, ultimately, the lease agreement that we look at isn't really representative or does not look like the lease that we just spent a significant amount of time negotiating. And so you want to put the right treatment plan in place and then ultimately make sure that you're reviewing all the documentation. And so again, depending on where you're at in your career, there are different goals and objectives for each individual. The 4 buckets that I really identify are startup or acquisition, renewal, expansion and relocation, or transition and sales preparation. So the key takeaways today, while your lease agreement is very important, the rental rates are important, it's not all about rent. You want to make sure you're maximizing your flexibility, minimizing any liability, really being strategic, and again, can't stress this enough, the bottom point, start the negotiation process as early as possible. Other than that, I want to thank you all for taking some time to join me this evening and or afternoon. Again, there are a limited number of free consultations available per webinar. For those of you who are interested in having us have a conversation with you that's more detailed or take a look at your lease agreement, I would be happy to assist you. I would just request that you do try and reach out to me this evening or tomorrow morning, because typically at that point afterwards, the consultations are no longer available or have been snatched up essentially. And so again, thanks for joining me. Hope you all found this valuable and enjoy the rest of your evening. Take care.